Okay, today we're going to talk a little bit about how you go about paying your reference-based repricer. Believe it or not, this is a pretty hot topic, pretty hotly debated in the world of reference-based pricing and how you go ahead and compensate that entity that's repricing your claims for you, right? Again, reference-based pricing is when we do not use a traditional network with respect to a health plan. We instead start with a cost basis or a reference point, such as Medicare, and we build up from there. We determine what would be a fair profit above that Medicare number or that cost number, and we pay our claims that way. And so by doing this, you literally end up cutting your claims costs in about half. Instead of paying an average of 311% for claims in California, you instead pay something like 150% for claims in California. So it's a big deal, right? And let's talk a little bit about the different ways that we can pay a reference-based repricer and what I think might be the best couple and why. So we'll go through the options. We'll talk about what I like to call a new entrant bias. So people that are new to reference-based pricing always gravitate towards one particular method. They have a bias toward it. It's understandable. We'll talk about paying for the actual work done and the expertise needed to reprice and negotiate a claim. We'll look at an integrated approach where the reference-based repricer also owns or is part of the same company as the TPA, maybe even the stop loss, the PBM, and then obviously provides the concierge as well. We'll look at a percentage of savings approach as opposed to a percentage of billed charge. In the next slide, we'll talk about these. And then we'll get into what I think is the winner or the winners, okay? So I've organized the options here. I think probably in the most top to bottom, one being the most popular or prevalent, all the way down to 6 being, I don't even know anybody that does 6. 6 was just an idea. I thought, you could do it that way if you're not happy with any of these other systems, but I just think it would be horrible to try and pay your reference-based repricer on an hourly basis. So per employee per month, the entities that do it this way typically charge anywhere from $20 to $30. And then you can purchase additional add-ons for either legal protection or balance bill support, or other billing enhancements that you can purchase, you can add on to that amount. Or you can go with, I think, the second most common method, which is a percentage of billed charge. And the entities that do the percentage of billed charge model usually do anywhere from 9 to 12% of the billed charge. And so they build it right into the claim. One advantage of this, you could say, is that stop loss is going to pay part of that, right? Because if you have a stop loss at 100K and you're talking about $1 million claim that gets negotiated down to 200,000, they're going to bill 10% of that 200,000, or in this case, obviously 20,000. That's just going to get tacked right onto the claim. So the reality is stop loss will be paying that charge for you on those really large claims. But of course, stop loss carriers don't love this either, and they account for it in their underwriting. Third would be a percentage of billed charge with caps per claim. I'll talk a little bit more about that later so that it's not just an unlimited percentage number. 4 would be a percentage of savings as opposed to a percentage of the billed charge. 5 would be a flat fee. And I've seen this, and it's typically only available after you have a couple of years of experience so that the repricer has an idea of how much work they're getting involved in. And then last, like I said, hourly. I mean, you could go there. I don't know if anybody does. I just was brainstorming every possible idea I could have on this topic. I just think that would be rough. I think those bills would get nasty quickly because you have a lot of different people sometimes touching a claim and working on it. If you have a true repricer who's negotiating on your behalf, as opposed to just somebody who's literally just repricing the claims with software only. I guess you could maybe do it that way. But anyway, I'll leave it at that. Okay, so knowing that healthcare prices are a joke, why would I base payment on them? I think that's a really good question. And for people that are first wrapping their heads around RBP, this tends to be the most compelling argument. it's sort of the default method, and it's for good reason. It's the most transparent and predictable method, and it's also typically the cheapest way to do reference-based pricing. But again, you get to that question in that third bullet, which is, why would I base my payment to the repricer on the unicorn riding, cotton candy eating price that facilities pull out of thin air while they're wearing their rainbow colored hats and dancing around in utopia? And so it's a good argument, right? Like, we know those prices are fake, we know they're phony, and so why would I want to pay my repricer on those prices? It's a really good argument, okay? And I think that's probably the most compelling argument for a PEPM method. Okay, on the flip side, and many people haven't even got this far typically, is what is the flip side? Well, what would be the argument for paying on a percentage of the billed charge? And that is that when you pay on the percentage of the billed charge, you're paying for the work actually done and the expertise needed to solve that particular claim. Now, if we're discussing a $5,000 claim, repricing it and then ultimately having to negotiate that if necessary with a facility is really not that big of a deal, and paying a repricer $25 PEPM for that is easy. I mean, it doesn't it doesn't make little sense. It makes good sense, right? So if we're discussing, though, think about a $1.25 million claim. And if that's the case, don't we want a higher level of auditors, attorneys, and negotiators on that claim who are also prepaid to be your legal defense? I think there's a good argument for this, folks. You want the people doing the work, you want economic incentive alignment. You want them focused on the biggest claims, because that's where they're going to get paid the most, and that's where they can make the most impact on your plan. You don't necessarily want them just processing every claim as fast as they can with technology and then moving on because they're on a PEPM. I think this is probably the more compelling argument for doing a percentage of billed charge model. So how about a fully integrated approach? This isn't really on pricing. This is kind of I kind of added this slide in as I was thinking about this. So I just want you to be aware of this because it's out there. Imagine Doug needs a shoulder surgery, and there's 2 qualified hospitals within 20 miles of Doug's house. So he calls the repricer, because in this example, the fully integrated is what I mean. The repricer, the TPA, sometimes the stop loss, and then the concierge service are all part of the same team. They're all owned by the same company, or they are all part of the same company. So the argument for that is efficiency, right? You get this efficiency of this unified system. We'll see how true that is in the long run. But so imagine Doug calls. There's 2 places that can do his shoulder surgery. And he calls to ask the concierge, the repricer, or the TPA, it doesn't matter in this case because they're all the same person in this case, they're all the same entity. Where should I go for my shoulder surgery? So the repricer, hammering on the keyboard, pulls up the data. They can see there's 2 hospitals within Doug's driving distance. And each of those hospitals, there's history that shows each one's going to settle for about $20,000 for that shoulder surgery. However, Hospital A always starts at a billed charge of $400,000, while Hospital B always starts at a billed charge of $150,000. Where is that repricer incentivized to refer Doug for his shoulder surgery? In a percentage of billed model, right? Let's just assume 10%. Let's say they're going to get, we won't do 12, which is the number thrown out there. We'll just say 10 to make it easy for a lawyer to do math here on the fly. If it's 10%, then the fee is going to be $40,000 to reprice that claim, because 10% of 400, or it's going to be $15,000, 10% of 150. So a cynical person, a pessimist, might argue that, wow, this repricer has a huge incentive to refer Doug to the higher cost hospital because that's how they maximize their fees. Now, I don't know if anybody actually does that, but I don't want that kind of economic malalignment within my plans, right? I don't like it at all. So And that's my job as an attorney, an advisor, a consultant, a broker, an agent. That's just an aside, folks. Can we figure out what we're called, right? We used to be brokers, and then there were agents, and then consultants, and now we're advisors. I hate the word advisor. It's the most flaccid one of all of them, right? It reminds me of the eunuch on Game of Thrones who was always whispering in somebody's ear. He never made any real decisions. He just whispered in ears. Whatever. I'm a broker. I'm an attorney. Whatever. I don't know what I call myself, but I'm gonna go with the term broker because at least people know what that means. All right, so I don't want that. I don't want there to be an incentive the wrong way. And that's exactly what happens with this model. Same thing with the percentage of savings model, right? It's the same exact problem. The savings number, so if they save you, in this case, $380,000, right? You go from 400 down to 20,000, that's $380,000 savings. If you do 10% of that, they get 38,000, etc. So they still have that incentive to refer you to the highest cost provider. No bueno. So in a PEPM model, actually, you don't have that malalignment. In fact, you arguably have good alignment because the PEPM model should be referring you to the low-cost provider because they know that's probably the provider that's going to squawk less at 20,000 as opposed to the provider that wants 400,000, right? Okay, so something to think about when you get pitched on that integrated model. We've got everything under one roof. Yeah, and we can steer you to the highest cost providers to make ourselves rich too. Okay, so doesn't the percentage of saving model make the most sense, right? I mean, that way, I'm going to pay based upon how much you actually deliver me. It's not bad thinking at all. But again, I've been in this game a while. I've been in court in these situations, and there are some reasons I don't like it. So I'm just going to roll out a hypothetical here so that it makes sense to you why I don't really like this method. And again, I'm assuming that litigation has become necessary and we're in court. Okay, I'm assuming that there's a dispute, right, between the facility and the plan. So let's assume that a claim started at 600% of Medicare, and we'll call that $600,000 for easy math. The facility did agree for access, right? We haven't got access yet, where this is a pre-negotiated claim. The facility agreed to accept $350,000 after a round of negotiation. Your typical national carrier, our data showed, would take about $325,000 for that claim. So at this point, a lot of employers might say good enough, right? But they also might say not good enough. I don't want to pay more than I would pay if I had a carrier. The repricer then encourages the employer to hold out and continues to fight to get that claim down to $250,000. 25 days later, call it a month, the repricer wins and reduces the claim down to $250,000. Now the plan participant, Patty, has access for her surgery. So going on to the next slide. Patty's in pain and really could have used that surgery earlier. Why did the repricer hold out? Was it so that they could earn their fee on another $100,000 of savings? Or was it so they could do the best possible job for the employer to negotiate the lowest reasonable claim cost? Percentage of savings models muddy the waters when we do this. And now imagine a situation where Patty ultimately sues the plan and the repricer for not getting her in for earlier care, causing her much more pain and anguish, right? Well, now this just got even trickier. And what if the repricer also agrees to become a co-fiduciary on the plan? A couple of repricers will do that. They say, we become a co-fiduciary. So now, if they become a co-fiduciary on the plan, but they're holding out for the lowest savings for themselves, and there's a point at which, you probably should give up on fighting for more savings to get the care necessary, right? You've got a little bit of competing, not totally divergent interests, but you've got competing interests, and you could get to the question to say, what master is the repricer serving at this point? So with a percentage of build, as much as we don't like the idea of that's a fantasy number, it makes no sense at all, the price is the price. There's no doubts that can creep in, because if you started at 600,000, everything's going to be based on that. And then everything the repricer does at that point in time is on behalf of the plan, because they're not fighting for a larger savings number for themselves. They don't have to serve two masters at that point, right? So imagine a situation where you're in court and you've got a judge or a jury who is well, you're going to have an opposing counsel questioning, but you've got a judge and a jury listening, and the opposing counsel is questioning you on, well, isn't it true, X Corp, Repricer, that really you wanted to negotiate a lower amount and you're claiming this is a reasonable amount because you're just trying to maximize your fee. And your fee gets maximized by more you save, right? It casts doubt upon the repricer's ability to be completely neutral and fair with respect to what that price should be. Okay, that's my problem with the percentage of savings model. It's probably a little bit hyper concerned as an attorney, but again, I've been through these situations, and so I've seen how that can play out. And for that reason, I don't love, as much as that makes intuitive sense, I don't love that method for repricing. So where does this leave us? Because the percentage of build model also typically comes with built-in legal protection, compensates the repricer claim by claim for the expertise and time needed to get the job done, and avoids the potential conflict that a percentage of saving model can create, I do think it's probably the best compensation structure for reference-based pricing. However, PEPM is a very close second because the percentage of build charge does not address the potential issue of steerage to a higher cost facility. Again, that's the cynic in me, but you know what? I work in healthcare and I've done it for a long time. So it's really hard not to be cynical because I've seen all kinds of just egregious, nefarious behavior at the business level. I don't ever see it at the provider level. I see it at the business level with hospitals, insurers, sometimes, not always, often. Okay, so how do you fix this? So how do you address this issue? Well, you can ameliorate the malincentive you have for steerage to higher cost facilities if you just go ahead and implement a cap on what your repricer can earn per claim. So I've seen that be $35,000 flat. I've also seen it be $25,000 for pre-certified claims as opposed to $50,000 for emergent claims. Either way, it's a great way to handle this because you put in the percentage of build charge model, you're paying your repricer more for the more work they're doing, the more important, the larger the claim, the more you want them to get paid, the more you want them to allocate negotiators, attorneys, claim adjudicators on that claim to make sure that what you're getting is exactly what you need to attack the largest claims. I just think that's probably the best way to go. But like I said, PEPM is also a very good, solid second. It just, PEPM does not typically come with legal protection and all of the extra that you get with the percentage of build charge model. So second to last bullet, after a couple of years of data, you should have a pretty good sense on how your plan runs. Are they heavy utilizers, light utilizers? And you can probably just work out a flat fee. You know, you could do a 10% of build charge with caps, individual fee caps, and then not to exceed, say, you know, $350,000 a year or something like that. Most repricers are amenable to that if they have a couple years of experience and they can see how the plan is running. And then lastly, hourly. I just can't imagine. I think that would be a nightmare. I can't imagine tracking it and paying it all the time. And ugh. But I had to throw it in there because it just kind of was obvious that that would be another method you could do. One other thing. People talk about, oh, that percentage of build model is ridiculously expensive. And it can be. It absolutely can be. I have heard stories from people who've worked on the inside at repricers that there are times they're making $140, $160, even $200 PEPM because they're at that percentage of build charge model. And typically that would be without caps, right? Without any kind of per claim cap. But I also know for a fact, there's cases of young, healthy workers that run lean that have maybe direct primary care as well. So there's not a lot of claims running through the repricer, and they're down at $3 or $4 PEPM. Again, that's a little bit of an argument for the percentage of build charge model, because in those, again, you're paying for the work that's actually being done. That's all I got on this one, folks. Thank you so much. And I will see you at renewal time.